let's get started with the default judgment. It's actually quite a pressing issue,
Yes.
and it's something that I've been experiencing in my practice. So obviously everyone knows, like, we are focusing on properties and things like that. There's plentiful occasions to do things like rental claims or any other claims. But I mean, a lot of the times you'd find rental claims in the courts. So the default judgment process in some of the courts, I don't necessarily want to name courts, unless it becomes pertinent. But what has been your experience as of late in getting default judgments out of the court? So how does the process work? Maybe just start from the beginning. How does the process work? What's a default judgment? And this perception that it's an easier way of doing things versus the actual amount of time it takes to do it.
Okay, so I'm going to try and keep it as simple as possible for the benefit of our viewers. Okay, so first off, like I just said, you have motion and action procedure. Motion procedure is what we normally use for evictions. Motion is where you start with a notice of motion and a founding affidavit. So that process is all based on affidavit, so based on paper. And you can only use that process if you do not have a factual dispute. A factual dispute is typically, say, for instance, we do not have a written lease agreement. See, so that's why we have written lease agreements. If you don't have a written lease agreement, you can't prove the facts that the parties agree to. There isn't common cause to show this is the facts of the lease agreement. Now we need to show what was happening in the transaction on oral evidence. So you need to lead oral evidence, you need to question and cross-examine, so you can get to what was the actual story behind the story. And we don't like that. So if you have everything on paper, you can do an affidavit. So instead of testifying with your mouth, you just sign an affidavit and you say, this is exactly what happened. This is the truth. And the other party does the same on their affidavit. And they say, okay, yes, I see you, but this and this and this, I think we misunderstand each other a little. And if it is to the point where the court can make a decision based on papers, so based on those two affidavits, there's usually a bit more affidavits, but work with me, on affidavit and on paper, if the court can make a decision from there, it will remain on paper. But if there's a factual dispute or there is another reason why you have to be on action procedure, this would typically be in the magistrate court. For instance, if you have an eviction application that is not governed by the Prevention of Illegal Evictions Act, so your commercial, retail, industrial evictions, or a rental claim where there's a factual dispute. And that factual dispute, very often on a rental claim, sits on something like the tenant said, yeah, but remember, I paid that amount cash once, or there's a damages claim that you need to prove that you can't prove as simple as on affidavit. Then you have to go an action procedure. And this is the one that we're talking about. That starts with a summons. Very often attorneys like to use action procedure on rental claims because in the magistrate court, you then have the benefit of the rent interdict summons. So that is perfection of your landlord hypothec in the form of a summons, and the items on the lease premises gets attached in terms of the summons up to the point where you obtain judgment. So that's typically the two reasons why you would be on action for rental claim. The thing is, the perception is, if a matter is undefended, okay, so again, for the benefit of our viewers, defended doesn't mean the party giving the defense or saying, no, I don't owe this money for this and this reason, is going to be successful with their defense. We have a rule in law called the audi alteram partem rule, which says both parties have the right to come to court and tell the court their side of the story. So a court can never say, no, whoa, I don't want to hear your story. But you can, I'll get to that now. But in most cases, you can't say, the court isn't allowed to say, I don't want to hear your story. Clearly, it is a load of nonsense and I don't want to hear your story. The court will have to look at your defense and then make a decision from there. If a matter is defended and the plaintiff, so the party bringing the action, issuing the summons, feels that the defense is fictitious or frivolous, and they want to say to the court, well, this guy is just trying to waste time, that's a different procedure, and that's called summary judgment procedure. Very often it sounds like that's a quick road to judgment, but especially in match court, the prospects of success if your application for summary judgment is defended, opposed in that context, actually, even if the defendant just says, you know what, here's a statement and here's a statement, I can show that I have a defense, a bona fide defense that the court will have to consider, the court's going to dismiss that summary judgment application. So for the benefit of our viewers, don't push your attorney to go on summary judgment where they advise you that the prospects of success are low. They're going to say, to advise you, we should rather give leave to defend after they've considered the summary judgment opposing affidavit, because we know, because we've been in court so many times, we know exactly how the magistrates react. If there is a slight chance that the defendant has a bona fide defense, there is no way that your summary judgment application is going to stand. The reason why your attorney is advising you against it is not because he's too lazy to go and argue in court. It's because we know, especially in the magistrate court, your prospects of success on summary judgment, especially on a rental claim, is much lower because it's a final order. It can go on appeal, where to grant leave to appeal isn't a final order, can't go on appeal. So this is very important. But now default judgment. If the matter remains undefended, you bring a default judgment application. In the High Court, it's nice because we can set it down on the roll and a judge actually hears it in open court. So you know that it's going to happen at a specific time. In magistrate court, how it works is amazing. You do an application, request for default judgment, and you say, on this date, the summons was issued. They had until this date to defend, they didn't defend, or they filed a notice of intention to defend, but they never filed their plea. You place them on terms. You served your notice of bar and they didn't file their plea, and now they barred from filing a plea. So can we now, please, court, obtain default judgment because the defendant didn't defend the action? And it sounds like a quick process, but it's not, because that thing gets filed. The clerk of the court has to take it to a magistrate. Now you hope and pray that a magistrate will receive the correct court file with the correct request for default judgment on top of it, and then actually has or find the time to consider this application and grant the order. At this stage, we very often, on average, we sit about, Bruno, tell me if you're on the same, about 4 to 6 months to obtain a default judgment application. I've had default judgment applications sit for more than 8 months. You send your messenger, your candidate attorney, everybody, go find the file. And then eventually, you get to the magistrate and you realize, well, okay, what happened, what went wrong here is the file slid off his desk and he's now lying there under a carpet or behind a counter. Nobody knows about it. Your clients scream at you, oh, how did you lose this? How is it taking this long? It's undefended. How can it take this long? There is a level of frustration that attorneys face that I don't think people really realize. And we're doing our utmost best to get these orders, but it does take a very long time. And very often, if you even send a crying candidate attorney to go and get the default judgment.
That used to be our trick.
It used to be my trick as well. I still remember, and I wonder if a lot of the attorneys watching this will know who I'm talking about. When I did my articles, Magistrate Gibbs, who's now an advocate, was still in Pretoria. And I remember I always went to him and I just cried and I'm like, I'm gonna get fired. But honestly, I think I would have been fired. I could have been fired easily. But can I please have my default judgment application? And then he made some time. But these days, even if you send a crying candidate attorney, the magistrate's workload is just so incredibly much that doesn't even work, and they get chased out. So it is tricky, and really nobody is not doing their job well. Okay, the attorneys are really doing their jobs and doing absolutely everything we can to in our power to try and obtain those judgments. My point with this is default judgment might not be your best bet. Remember, for a rental claim, we do have the rental housing tribunal, really a much quicker process, much cheaper process. So don't just push to the marriage court because you think it's a more powerful thing. An order from the tribunal carries the exact same way.
Absolutely, and I mean it's such an interesting dynamic. So the legal process in itself, just from the consideration of legal aspects, the drafting of documents, making sure they're accurate. So like on rental claims, like the example of damages affidavit by estate agents, where we need to value for some reason or another, the value of occupation, where something's wrong with the lease agreement or you don't have a proper value in place, you need to bring in expert. And this stuff takes time. So drafting a summons takes time. Some summonses for rental collections are run of the mill. But as soon as there's certain deviations, things happen where the lease was cancelled and then brought back and then cancelled, and then there was a little sub-agreement and then a little piece of paper here and an email here and stuff like that. These stuff needs to be disclosed. So it's not run-of-the-mill, takes time to draft. Damages affidavit takes time to draft. So there's certain components of the work that attorneys do that in itself, like, it takes time. It's work that needs to be done because it needs to be done up to a certain standard acceptable by the magistrates. The difficulty then with this is on top of this, once the work is done, you're like, well, the process is there. Now it's simply a matter of starting it on this side and it'll come up on the other side with the result. That is now also, and it's been under scrutiny. Default judgments lesser so in the past than our trials, but now our default judgments are there as well. So we are kind of sitting at a difficult point where, again, going back to, if you can avoid litigation, it is ideal. If you can use other means. So as an example, Cilna, our rental housing tribunal, like, totally with you there. And if you need to use an attorney, use an attorney. You might not have time in your day to go there yourself. Cool. Yeah, there's no issue using an attorney. We even started now. So we even started now doing divorce mediations. So through Intergen, right? So Intergen does a lot of the tax paying and stuff like that. We've actually started doing now divorce mediations for divorce attorneys who are trying to find solutions to problems. They're trying to get these people to sort each other out. And we actually come in from a commercial perspective because it's become so difficult to litigate. It's become so expensive that they actually come and say, listen, let's maybe take the emotion out of it. You guys do planning with tax and stuff. Figure out how we can make use of these assets so that they don't fight. Maybe they can keep them. Everyone benefits from it, or you liquidate in a specific way, move the assets around, and everyone kind of gets 50-50. And it's just gotten to that point where even people that used to make money from litigation are going, too much. Like, it's too much.
Yeah, it's exactly. I mean, we actually started doing tribunal, representing clients in the tribunal, and I would much rather tell a client, let's go to the tribunal again, have a fixed charge. Client knows exactly what it's going to cost, but the difference is you send a candidate attorney at a fixed charge. Still, you get the same quality result because you get a judgment that carries the same value as or weight as that of a marriage court judgment. So kudos to you guys on the divorce thing. I think it's amazing. I think it's actually pretty cool to know that attorneys are doing our utmost best to keep our clients out of court and really act in their best interest. I think that is what our job as attorneys are, actually.
Yeah, and I mean, so I've always done commercial mediation. And it is getting to a point where even our emotional matters are coming down to approaching it from a commercial perspective. Like, what is the rand and cent value? Can we just get done with it? Like, how much do you want? How much do you want? How do we make it happen? And how do you pay the least amount of tax doing it? Okay, great. There you go.